Hello everyone, we present you the case of Nissan Motor Manufacturing Corporation USA versus US, where Nissan Motor Manufacturing Corporation USA is plaintiff and United States stands as defendant. This case was brought on February 2, 1982 in International Court of Trade of United States. And during that time, Free Trade Zone Board was regulated by ruling government, that is Congress. The case was again pleaded second time on May 1982, and the case was resolved on August 16, 1988. What is the case about? The case was about the conflict whether machinery imported by Nissan to produce merchandise in a foreign trade zone should be subject to duty or not. So, in this video, we will go through the background of the case. We'll talk about free trade zones and its benefits. We'll discuss about Nissan activities and we'll provide some relevant examples and come to the outcome of the case. Will also lead to the logical conclusion.
As per provision 15 CFR under section 400.101 1988, free trade zone is an isolated, enclosed and policed area operated as public utility in or adjacent to a port of entry, furnished with facilities for loading, unloading, handling, storing, manipulating, manufacturing and exhibiting goods, and for reshipping by land, water or air. Talking about other benefits, foreign trade zones often permit an importer to lessen its liability for duties or avoid quota problems. Actually, original Foreign Trade Zones Act did not permit merchandise to be manufactured in a zone. As per provision 19 U.S.C. under section 81AE and F 1982, the Foreign Trade Zones Act is administered by the Foreign Trade Zones Board, which has authority to grant to public and private corporations, and it has privilege of establishing, operating and maintaining foreign trade zones in or adjacent to United States Customs port of entry as per provision 19 U.S.C. under 81BA.
As my previous group members mentioned about the case and also they spoke about the foreign trade zones and its activities, now I'm going to talk about the facts which Nissan wanted to implement in this case. Nissan started their business in USA around 1960. As they have started their business, they wanted to take the advantage of foreign trade zone by implementing a test in substance of Smyrna, Tennessee. They were proposing that they will build a conveyor and stamping systems, industrial robots and a complex computerized interface, and they wanted to ignore the taxes as they were doing the business under the ruling of foreign trade zones. In the proposed final configuration, Nissan noted that it was uncertain whether the machinery would be capable of full-scale production of motor vehicles, and that machinery needed to be assembled, installed and tested. As a result of this, Nissan stated that some or all of the machinery might be returned to the foreign manufacturers, replaced, redesigned or scrapped as useless. Upon the facts, Nissan presented custom decided that production equipment imported into a foreign trade zone is not merchandise for purposes of the Foreign Trade Zones Act. So this is, by the act, it is dutiable.
While the argument went forward, the defendant compared another similar case of Hawaiian Independent Refinery versus United States, as Nissan's case was not the first judicial review of the dutiable status of import in foreign trade zone. In Hawaiian case, they were importing crude oil into foreign trade zone. Some of them processed crude oil was then stored and used as needed as a source of fuel for the refinery operation. On the basis of Foreign Trade Act, the place is basically used for loading, unloading, storing and manipulating products, and also certain products are dutiable if they've been consumed. The Hawaiian was subjected to pay the tax as per the Foreign Trade Act. According to the customs, it needed plaintiff to file a consumption entries for refined crude oil used as fuel within the zone and classified the fuel under the tariff schedule of the United States. However, the plaintiff protested the customs decision and claimed the refined crude oil was not subjected to duty because it never entered the customs territory. Hence, court reads its decision that plaintiff has to pay the tax for anything that was consumed. Court also found that some of the refined oil was used for the free trade zone.
Alright guys, time to conclude the case between Nissan Motors Manufacturing Company versus United States held in the Court of International Trade. As a matter of fact, court found two things. First, Foreign Free Trade Board did the right thing, not stopping Nissan to bring the imports on foreign trade zone, neither restricting their protest against board itself, and also did not sign any contracts. And on the basis of act, they collected the import duty on the material bought by Nissan. Second matter of fact, when the defendant compared this case with another case, which was Hawaiian Independent Refinery versus United States, in which plaintiff as an Hawaiian refinery was subjected to pay the tax as refined oil was used to run the plant on free trade subzone under Free Trade Act. So on the basis of following things, Nissan was also not eligible for any tax exemptions or reliefs. Hence, Nissan plea was rejected in the Court of International Trade on August 16, 1988, and court did not revoke any given statements for not paying the $300,000 penalty or as an import duty tax on the materials bought on the free trade zone.